Good afternoon to all, and welcome to the weekly business meeting of the South Carolina Public Service Commission. Today is Thursday, October 10th, 2024, and it's approximately 2 p.m. Before we begin, would you please join me in a moment of silent reflection? Thank you. Thank you very much. First, a roll call of commissioners. All commissioners are present here in the hearing room. Ms. Scarborough, if you would, please proceed.
Yes, sir. The first order of business is to set the next regularly scheduled business meeting. Staff recommends that the next commission business meeting be set for Thursday, October 24th, 2024 at 2 p.m.
All right, the next business meeting will be October 24, 2024 at 2 p.m.
Thank you, sir. Today we have 8 items on the utilities agenda and 5 items on our transportation agenda. Item number 1 appears in docket number 2024-230G. This item involves final disposition of this docket.
Having heard the item is read by Mr. Scarborough, do I hear a motion?
Chair Powers.
Commissioner Thomas.
Thank you. I move that the commission approve Dominion Energy South Carolina Incorporated, DESC, annual update on its gas demand-side management, DSM programs, and its petition to update its rider as modified by the recommendations of the Office of Regulatory Staff to DESC's gas demand-side management programs, the DSM programs. DESC originally requested cost recovery of $401,488. DESC's gas DSM programs were first offered to customers beginning in late December 2022 and have not yet achieved DESC's forecasted participation and savings goals. DESC conducted limited program marketing in the initial months while providing contractor education and training, and completed small batches of projects to test implementation processes and gauge customer response. ORS will monitor actual customer participation and therm savings compared with the company's forecasts, and will determine if any adjustments to forecast methodology is appropriate for future filings. ORS calculated a total expense adjustment to remove $8,317 related to DESC's annual incentive plan objectives and $49 related to DESC's employee service and retirement awards, for a total expense removal of $8,366. With the adjustments recommended by ORS, the updated gas DSM rider rate was developed in accordance with the terms and conditions set forth in Commission Order Number 2022-644. As a result, the Commission adopts and approves the following gas DSM rate rider as recommended by ORS, which is illustrated in the table below, so that residential DSM rider cost is 0.0021 cents per therm, and commercial DSM rider class is 0.00019 cents per therm. On October the 7th, 2024, DESC filed its updated gas demand-side management rider incorporating the adjustments proposed by ORS and approved by the Commission. The updated gas demand-side management rider is approved by the Commission and shall be effective for bills rendered on and after the first billing cycle of November 2024. The Commission will issue a full order detailing the specific findings of fact and conclusions of law related to this decision. Unless specifically addressed in the Commission's order issued in this docket, nothing shall change any requirement or ruling made by the Commission in Order Number 2022-644 and Docket Number 2021-361G, dated September the 23rd, 2022, establishing and approving natural gas energy efficient programs for Dominion Energy South Carolina Incorporated. and in order number 2023-845 in docket number 2023-243G dated November the 16th, 2023. So move.
Thank you, Commissioner Thomas. Having heard the motion made by Commissioner Thomas, is any further discussion?
Mr. Chairman, may I ask for a clarification?
Commissioner Belser?
Commissioner Thomas, I think I heard you say with regard to desk, original request, I think I heard you say 401,488, and my notes reflect 401,448. I may have misheard, but I just want to make sure it's in the original request.
Okay, I think I was referring to, did I read it incorrectly? I'm not sure. So
I just want the record to reflect that I have down that the original request was $401,448. Do you agree with that?
I do.
Okay, thank you.
Thank you.
Thank you, Commissioner Belser. Any further discussion? Hearing none. All in favor signify by saying aye.
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 Those opposed by saying no. The motion carries.
Item number 2 appears in docket number 2023-390E. This item also involves final disposition of this docket.
Having heard item 2 is read by Mr. Scarborough, do I hear a motion?
Chair Powers, I'd like to make a motion.
Commissioner Williams?
Thank you. I move that the Commission declines to approve the proposed residential service tariff on bill pilot program, the TOB pilot or pilot, requested by Duke Energy Progress, LLC, for a period of 3 years. The pilot impermissibly requires non-participating customers to fund participating customers' financing of energy efficiency and conservation measures in direct contravention to South Carolina Code annotated Section 58-37-50, which limits recovery of cost under the statute to customers directly benefiting from the installation of such measures. The recovery of cost associated with the TOB pilot, both directly and indirectly, from non-participants through general base rates is not reasonable or equitable. In addition, we find that the company's application fails to adequately identify and set forth that all residential customers, not just program participants, will be responsible for general cost associated with the administration and the implementation of the TOB pilot. While the pilot program was part of the settlement agreement from a recent case in Commission Order number 2023-138 and docket numbers 2022-254E and 2022-281E, we believe that this pilot needs more development concerning implementation as well as further review with stakeholder groups. The Commission will issue a full order detailing the specific findings of fact and conclusions of law related to this decision. And Chair Powers, I have comments I would like to make.
You have the floor.
Thank you. This motion is really hard for me to make. I believe in the opportunity for tariff on bill financing for energy efficiency programs to create system-wide benefits as Duke Energy Progress described them. By that, what I think they mean is the opportunity to shave the peak and avoid costly new generation as long as possible. These programs are good for homeowners in older homes without the latest and most efficient HVACs, thermostats, and more. These programs are good for renters whose landlords agree to participate. Do the programs have challenges and potential pitfalls? Yes. That is why the company is proposing a pilot program limited to 1,000 participants. But yes, I did make the motion to deny this application. Here is why. The cost should be borne by all residential ratepayers or all ratepayers if that is where the benefits lie. In the pilot phase, it could be designed to be borne by only those who will benefit or the company's shareholders or some combination. If successful in the pilot phase, the program might ultimately be borne by all ratepayers, as I mentioned, based on merits of a system-wide benefits. By this, I mean we would say that all ratepayers would save more than the program cost. If the program is being proposed because of system benefits, those need to be calculated as a byproduct of this pilot program. With those benefits towards reducing system generation needs, then the company may have the data upon which to substantiate why and by how much all customers benefit. Potentially, those may include non-residential customers. State statute only references cost recovery for the cost of the energy efficiency and conservation measures and their financing cost. State statute does not provide specificity regarding any limitations on who may bear the administrative or programmatic cost. Other programmatic details, such as the role of a landlord and the realities of suspending the program when the one-year Treasury rate falls below 4.5% as it is now, are details that need to be improved. I considered whether there should be a different standard for pilot programs, given their temporary and their knowledge-building nature. However, we do not have statutory or regulatory support for treating them any differently. Finally, in making this denial, I personally welcome the company and stakeholders working on their tariff on bill program and reapplying. Thank you, Chair Powers.
Thank you, Commissioner Williams. Any further discussion? Commissioner Belser.
Commissioner, I'd like to make a substitute motion, please, Mr. Chair.
Certainly.
Well, let me just say, first of all, that I respect Commissioner Williams' position. I just disagree. And certainly can tell that she's put a lot of thought and work into her position. But I'm going to make a substitute motion and move that the Commission approve the tariff-on bill pilot program for Duke Energy Progress, LLC, subject to the conditions contained in this motion. As stated, the TOB pilot shall be for a period of 3 years or when enrollment reaches 1,000 premises. Under the TOB pilot, a participating customer will repay costs related to purchase, installation, warranties, annual maintenance, and financing costs through the customer's monthly electric bill over a 10-year period. As recommended by the Office of Regulatory Staff, DEP shall file annual reports that include the 13 topics recommended by OR Witness HIP. These topics will be listed in the directive and the order if this motion passes, but I'm not going to read them all here. They were very clearly set out in her testimony. These annual reports shall be filed with the Commission and provided to ORS and to the other parties in the docket. If information required for why and information required in the annual report is not available, DEP shall provide an explanation to why the information is not available. With regard to the cost for which DEP stated it may seek recovery from non-participants of the TOB pilot, I move the Commission deny ORS's recommendation to treat certain costs as below the line cost and find that DEP may seek cost recovery in a future rate case or other rate proceeding as may be appropriate. With regard to these costs, which may be sought from non-participants, I move that DEP be required to track and record the costs so that any cost for which recovery is sought may be appropriately reviewed. Costs shall be tracked in sufficient detail, including amount, reasons for cost, and why recovery is appropriate, to allow the Commission and any party to the proceeding where cost recovery is sought to determine the reasonableness and prudency of the cost for which recovery is sought. Any cost for which DEP will seek recovery from non-participants, such as but not limited to general costs associated with the administration and implementation of the TOB pilot and any incremental costs such as billing system upgrades, must be tracked in detail to allow review by the Commission and parties in a rate proceeding. Cost allocation will be determined in the rate proceeding where cost recovery is sought. I move the Commission approve the participant agreements with ORS's recommended recommended edits as contained in ORS Witness HIP's surrebuttal exhibit, which was admitted into the record as hearing Exhibit 5. Should DEP seek to revise or amend the participant agreements, DEP shall file the proposed revised or amended contracts with the Commission for approval. I move that a full order will be issued on this decision, and I do have some comments, Mr. Chairman.
Thank you, Commissioner Belser. Is there further discussion on the substitute motion?
Mr. Chairman, thank you. The purpose of the pilot is to determine whether it will be beneficial to the entire system and then open to the entire customer base. The costs that are specified as recoverable through the meter conservation charge in the statute, which is what 583750, limits the cost that can be recovered from the participants. I found that the estimated expenses for the 3-year pilot were not outrageous. They seemed very reasonable to me going forward. Now, I say that, and I am not saying that guaranteeing any kind of cost recovery. Duke Energy Progress will need to make their presentation if they seek to recover those costs in an appropriate rate case proceeding. But I think that they should be allowed that opportunity to do so. I think that also if they decide to file for a permanent and not just a pilot, they will need to provide significant detail as to benefits to the customer base and to the system that would guarantee, or not guarantee, but show that the benefits are there system-wide. But I do think they made a sufficient showing to warrant proceeding with the pilot. And that's my motion, Mr. Chairman. Thank you.
Thank you, Commissioner Belser. Any further discussion?
Mr. Chair.
Vice Chair.
Thank you, Mr. Chair. Commissioner Williams, Commissioner Belzer, thank you for your motions. In this case, I tend to agree with Commissioner Belzer, and here is why. When I reviewed the statute, the definition of the meter conservation charge, I read that definition to cover the financing costs and of the energy and efficiency conservation measures that would be charged to the participants of the program, which is in line with 5837D, which reads that an electricity provider or natural gas provider may recover the costs, including financing costs, of these measures. And again, the measures would be the measures to install, finance, maintain the efficiency, the energy efficiency and conservation measures. Those costs are different from the administrative costs, which include and not limited to the marketing and administering of the particular program. To me, that's important because without paying close attention to where the costs are stemming from, it could be taken that a non-participant is essentially paying for or helping pay for participants' new energy efficiency or conservation measures directly. And that's not what I believe is happening here. I believe the participants are paying for the equipment, they're paying for the financing of the equipment, they're paying for the installation. I think non-participants and participants alike are paying for the administration of that program. Whether or not the administration costs or program costs, if you want to call them those, are reasonable and prudent, that would be determined. What I will say is 1.1 to 1. What I will say is that those costs are costs that may or may not be proven to be reasonable and prudent, but this is not the time to make that decision. I also think it's important that, well, let me say for me, we live in some pretty uncertain times. We just had Hurricane Helene. Floridians are suffering from Hurricane Milton as we speak. And I don't want to create an environment where utilities don't feel encouraged to innovate and to do everything they can to provide the necessary energy, electricity in this case, that ratepayers have come to expect. This is a pilot program, as we all know, and we heard that the utility is trying to address the peak, and they're trying to encourage energy efficiency and energy conservation, which they believe this program will provide for the entire system. I don't think there's anything in their presentation that creates the need for the commission to be concerned at present. I think it creates an opportunity for us to learn and an opportunity for a program that has yet to be seen in South Carolina to be offered to ratepayers to make a determination as to whether or not the benefits are there. Again, those things are yet to be determined, but you never know if you don't try. Thank you, Mr. Chair.
Thank you, Vice Chair. Any further comments?
Chair Powers, quickly.
Mr. Caston.
I certainly appreciate the passion on both sides. I will not be able to support Chair Belser's motion. I would Commissioner Carolee Williams. I do personally and respectfully believe that the record does show that there will be a cost to non-participating customers. You know, sometimes, just a personal opinion, I feel like sometimes, you know, there may be forced benevolence, and forced benevolence isn't benevolence. The concept and ideas, I think, are wonderful. But I believe it does violate the statute, and we, you know, simply shouldn't approve it. We should deny it and encourage the company and others to come back with something that doesn't cost non-participating customers. And that's all I have, Chair.
Thank you. Any further discussion?
Chair Powers.
Commissioner Williams.
Thank you. There is almost nothing that I would like better than to be supporting Chair Belser's motion. And I have really, really tried to do that. The life of on-bill financing is something I delved into 10 years ago, and I believe in it. And to respond to Vice Chair Williams, it pains me to be to not able to support the company in this quest. And I really do sincerely hope that there will be another application. When I looked at the lack of detail in the statute regarding the program fee and or the administrative fee, I know that that's really up to us where there's not definition in how we should treat that. And so then I went to thinking about, what is a pilot? How have we established that? Do we have rules for what we permit and would not permit within a pilot? And I couldn't go any farther beyond that. So just explaining my background there. We don't have rationale for having a different standard. And then ultimately, it really came down to it's my understanding that in this particular application, every potential person impacted by the application should have been put on notice. And initially that notice did not, or not initially, but the notice that came about initially was entirely focused on the participants. And for that reason, I think can't quote regulations, but for that reason, I will not be able to support Commissioner Belser's motion despite my desire to support it. Thank you.
Thank you, Commissioner Williams. It's my turn. I've had the problem I've had with this is that as with some other programs, the company takes position if they can't get 4% off the top, that they're just not going to do it. There's no number that's negotiable or anything reasonable. I know my bank on my checking account pays 0.01%. And if I can get 4%, I believe I'd be moving it. Just have a problem with it. Commissioner Williams, this is something I wanted to ask you. Are you denying the program so much as just sending them back to the drawing board?
Thank you. I appreciate the question. I'm denying this application. I'm encouraging them to come back to us. I would be happy to take a friendly amendment to my motion that clarifies that.
All right.
But I think we have a question on the floor.
We do. And first, let me say that in this particular case, Commissioner Thomas, you were accused for being out at that time. Is that correct?
Yes, sir. I will not be voting. I was on annual leave.
All right. Thank you, sir. Looks like the vote is pretty much split. I'm going to ask for a roll call vote, beginning with Commissioner Belser.
I vote aye.
Commissioner Caston.
No.
Commissioner Williams.
You're next.
Oh, me? This Williams. Aye.
Commissioner Carol Lee Williams.
And for clarity, I am voting no on Commissioner Belzer's motion.
And I vote no. The motion fails by a vote of 3-2. This brings us back to the original motion. Is any further discussion on Ms. Williams' motion? If not, we'll have a roll call vote on that. Starting with Commissioner Williams,
Aye.
Commissioner Belser,
Aye.
No. You want to go? No.
Please.
all right? Commissioner Caston,
No, aye.
Vice Chair Williams,
I respectfully vote no.
and I vote aye. The motion passes.
Item number 3 appears in docket number 2024-245E. This is a letter from Dominion Energy South Carolina Incorporated withdrawing its application for a certificate of environmental compatibility and public notice and public convenience and necessity for the construction and operation of the Ritter-Yemassee 230 kV line, number 2, the Kennedy's Ritter 230 kV line, and associated facilities.
Thank you, Mr. Scarborough. Do I hear a motion?
Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, I move that the commission accept for filing and information the letter of Dominion Energy South Carolina Incorporated withdrawing its application for a certificate of environmental compatibility and public convenience and necessity for construction of Ritter Yemassee 230 kV line number 2, Kennedy's Ritter 230 kV line, and associated facilities. The clerk of the commission is directed to administratively close docket number 2024-245E. So moved.
Thank you, Vice Chair Williams. Having heard the motion, is any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 4 involves a host of dockets, all of which are listed in today's agenda. This item concerns establishing proposed procedural schedules for 2025, 2026, and 2027.
Do I hear a motion?
Mr. Chairman,
Commissioner Belser.
these dockets are annual cases that we hear that are on a pretty regular schedule, not pretty regular, but regular schedule. Therefore, I have a motion, and I move that the commission adopt the commission schedules as proposed for calendar years 2025, 2026, and 2027. Attached exhibits A, B, C, and D will be attached to the motion. I would ask that the full and proposed commission calendars be attached in their entirety, and issued with the directive on this matter. I also move that the commission staff be allowed to modify this schedule as necessary, since we're looking a little far out. And I have a comment too, please.
Certainly, go ahead, Commissioner Belcher.
Mr. Chairman and members of the commission, I would like to commend the chief clerk and the parties to these dockets. I know that they tried to work together to come up with these scheduled hearings, and that would be that are going to be memorialized in the calendars that will be attached to my motion. But just like to thank them for their work. It takes a lot to make sure that this commission runs as efficiently as possible, and the commission staff should be commended, and as well as the parties, because sometimes we have to ask them to alter what they would want to be able to work with other parties and with the commission. So it really is a joint effort, and I just thank everybody for their work on that. Thank you.
Thank you, Commissioner Belcher. Is there further discussion? Hearing none, all in favor signify by saying aye.
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 Those opposed by no, the motion carries.
Item number 5 is in dockets numbered 2023-211WS and 2024-27WS. This is a request from the Office of Regulatory Staff for confidential treatment of the direct testimonies and exhibits of Daniel P. Hunnell II, Dawn M. Hipp, and Alan Merzad.
Thank you, Mr. Scarborough. Having heard item number 5, do I hear a motion?
Chair Powers,
Commissioner Casson.
I move that the commission grant the request of the Office of Regulatory Staff for confidential treatment of the direct testimonies and exhibits of ORS witnesses Daniel P. Hunnell II, Dawn M. Hipp, and Alan Merzad pursuant to order number 2005-226.
Thank you, Commissioner Casson. Is there any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed by saying no, motion carries.
Item number 6 is in docket number 2024-6G. This item involves final disposition of this docket.
Do I hear a motion?
Chair Powers, I'd like to make one.
Commissioner Carolyn Williams.
Thank you very much. Pursuant to the provisions of the Natural Gas Rate Stabilization Act, also known as the RSA, codified at South Carolina Code Annotated Section 58-5-400-Exec, Dominion Energy South Carolina filed its quarterly monitoring report for the 12 months ending March 31st, 2024. DESC proposed adjustments to provide the opportunity to earn the midpoint of the range of rate of return on common equity pursuant to Order Number 2005-619. In the March 31st, 2022 monitoring report, DESC reported an adjusted rate of return of 6.86% and a return on common equity of 7.89% and requested an increase in revenue requirement of $13,088,132. ORS examined the operating experience reported by Dominion Energy South Carolina for the review period with the associated revenue requirement of calculations. ORS filed its report on August 30th, 2024. ORS made accounting and pro forma adjustments, reducing the company's request by $1,597,210, or a 12.2% reduction. The appropriate retail revenue target increase determined by ORS is $11,490,922, compared to the $13,088,132 as proposed by the company. ORS and Dominion Energy South Carolina entered good faith negotiations, ultimately resulting in a settlement agreement which incorporates agreement of all issues as to all parties. I move that the Commission adopt and approve the settlement agreement, which will provide as follows: an increase in current margin rates totaling $12,829,468 based upon the settlement accounting adjustments agreed to by ORS and Dominion Energy. A debt equity ratio of 47.34% over 52.66% and rates based on a 9.49% return on equity as approved in Order Number 2023-737A. This equates to a reduction of $258,664 in margin rates for South Carolina ratepayers when compared to the rates calculated based on the company's position as originally filed in its quarterly monitoring report. Additionally, the Commission requires that the following terms as reflected in the settlement agreement be ordered. A, Dominion Energy South Carolina will adopt ORS's recommendation to update the company's schedules in the amount of $24.89 as identified in ORS's reply comments. B, Dominion Energy South Carolina will adopt ORS's recommendation regarding property taxes as set forth in ORS's reply comments. C, pro forma adjustment number 21 entitled Working Cash per Gas Lead Lag Study should be calculated to total $16,710,927, along with the associated fallout adjustments of customer growth and tax effect of annualized interest. D, pro forma adjustment number 11 entitled Incentive Compensation Adjustment should be calculated to total $2,444,892, along with the associated fallout adjustments for taxes other than income tax, state income tax, and federal income tax. E, Dominion Energy South Carolina will adopt ORS's recommendations regarding economic development grants, sponsorship expenses, and related tax credits. F, if not otherwise specified, Dominion Energy South Carolina will adopt other ORS's adjustments as set forth in the ORS report. And G, Dominion Energy South Carolina and ORS by March 1st, 2025 shall work collaboratively to determine for future RSA proceedings a methodology to calculate the company's working capital and the calculation of incentive compensation adjustment. No later than October 14th, 2024, Dominion Energy South Carolina is ordered to prepare and file schedules containing the rates and charges resulting from these adjustments, subject to confirmation and check by the Office of Regulatory Staff. A full order will be issued no later than October 15th, 2024.
Thank you, Commissioner Williams. Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by saying no. Motion carries.
Can I just note one clarification?
Certainly,
With
Commissioner
regard to the pro forma adjustments for working cash, the lead lag study and the incentive compensation adjustment, I would just like to note that those are deductions. The numbers were read, but those are deduction numbers. Thank you.
Thank you for the clarification.
Thank you.
So that's true for C and D.
All right.
Item number 7 appears in docket number 2024-144E. This is a request from the Office of Regulatory Staff for expedited consideration that the Commission hold in abeyance this docket and all remaining testimony deadlines.
Having heard the motion, having heard the item by Mr. Scarborough, do I hear a motion?
Chair Powers.
Commissioner Caston.
I move that the Commission hold docket number 2024-144E in abeyance pending further action of the Commission.
Thank you, Commissioner Caston. Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The motion carries.
Item number 8 is in docket number 2024-278C. This item involves the appointment of a hearing examiner in this docket.
Thank you, Mr. Scarborough. Having heard item 8, is there a motion?
Mr. Chairman,
Commissioner Belson.
I move that the Commission appoint J. Adam Russell, Esquire, as hearing examiner in docket number 2023-287E. Thank you.
Thank you, Commissioner Belson. Is there any further discussion?
Clarification. I think that the docket number is 20.
Should be thank you, Commissioner, 2024-287E.
Thank you,
I
Commissioner.
believe it is
278. I'm just messing up everywhere. Let me
dash.
try again.
You made up by correcting me.
Let me try again. 2024-278C.
All right. Having heard the motion, is there any further discussion? All in favor signify by saying aye.
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 Those opposed saying no, the motion carries.
Mr. Chairman, that completes the utilities agenda before the commission. Moving on to the motor carrier agenda, in Part A, we have 3 applications for new Class C certificates. These items can be taken together. Item A1 is in docket number 2024-267T, which is the application of Patient Response Organization, Incorporated, for a Class C non-emergency certificate. Item A2 appears in docket number 2024-268T. This is the application of Adventure Sightseeing of Carolina, LLC, doing business as Adventure Sightseeing for a Class C charter bus certificate. Item A3 is in docket number 2024-269T, which also is the application of Adventure Sightseeing of Carolina, LLC, doing business as Adventure Sightseeing for a Class C charter certificate.
Thank you, Mr. Scarborough. Having heard items A1 through A3 as presented, is there a motion?
Chair Powers, I'd like to make a motion.
Thank you, Commissioner Williams.
Thank you. I move that the commission approve the applications for Class C certificates in item numbers A1 through A3 as identified by Mr. Scarborough. A directive order will be issued for each application in the respective dockets.
Thank you, Commissioner Williams. Is there any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed saying no. The ayes have it, the motion carries.
In Part B of the transportation agenda, we have 1 request to cancel a certificate. Item B1 is in docket number 2009-345T, which is a request from RW Transportation, LLC, to cancel Class C non-emergency certificate number 8169-A.
Is there a motion?
Chair Powers.
Commissioner Thomas.
I move that the commission grant the request of RW Transportation, LLC, FKA Ruth A. Williams, DBA RW Transport, for cancellation of its Class C non-emergency certificate number 8169-A.
Thank you, Commissioner Thomas. Having heard the motion by Commissioner Thomas, is there any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed by saying no. The ayes have it, the motion carries.
In Part C of the transportation agenda, we have 2 requests for extensions of time. We'll take these separately. Item C1 is in docket number 2024-171T, which is a request from Alleycat Transport, LLC, for a 12-month extension of time to comply with commission rules and regulations.
Thank you, Mr. Scarborough. Do I hear a motion?
Mr. Chairman,
Commissioner Belser.
I move the commission grant the request of Alleycat Transport LLC for an extension of time until June 26, 2025 to comply with the commission rules and regulations. This extension represents 12 months from the directive order date granting the company's application for Class C taxi certificate. If the company fails to come into compliance with commission rules and regulations by June 26, 2025, no further extension will be granted. However, the company will not be precluded from filing a new application at that time. So move.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, do I hear any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed by saying no, the motion carries.
Item C2 is in docket number 2024-198T, which is a request from Top Tier Transportation Services, LLC, for a 9-month extension of time to comply with commission rules and regulations.
Having heard item C2 as read by Mrs. Scarborough, do I hear a motion?
Chair Powers.
Commissioner Caston.
I move that the commission grant the request of Top Tier Transportation Services, LLC, for an extension of time until June 25th, 2025, to comply with commission rules and regulations. The extension represents 9 months from the request for an extension of time and 11 months from directive order date granting the company's application for Class C non-emergency certificate.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is there any further discussion? Hearing none, those in favor signify by saying aye.
Aye.
Those against by no, the motion carries.
Mr. Chairman and Commissioners, this concludes all business noticed before the commission today.
Thank you, Mr. Scarborough. again this week, I ask that we please remember all those who are working tirelessly to deal with the effects of these storms, whether it's utility workers, first responders, volunteers. Help out where you can. I'm personally am tired of hearing the word catastrophic, but that is exactly what we are dealing with and what is before us now. Have a great weekend and enjoy both Columbus Day and Indigenous Peoples Day. We are adjourned.